Welcome. My name is Christina Fitzpatrick, and I'm the Director for Economic Issues in AARP's Office of Policy Development. If you're just tuning in to today's kickoff event, we're about to start a session about who's left out of income security programs, focusing on workforce issues. If you weren't able to join us for the session just before this one, we had a 1-hour Songs of Social Insurance session. And we, in the chat session, you're going to be able to see the link to the playlist, which you'll be able to listen to at any point. And there's also a link to the voting site, so you can vote for your favorite one. This is one of the many ways that the National Academy staff has shown their creativity for the event today, and I want to give them a shout out for that. And vote for your favorite one. This is one of the. I definitely suggest that you check out Item A, the story of the first Social Security check being given out. And I also have a soft spot for Unemployment Blues if you are a reggae fan. Indy?
Thank you, Christina. I'm Indy Dattagupta, member of the Academy's Board of Directors and co-executive director of the Georgetown Center on Poverty and Inequality. Before we get started, first a quick reminder that at 5 p.m. Eastern today, we have a social insurance appreciation hour. If you've already purchased a ticket or sponsorship for the full ball award campaign, you've received the link for the social hour, but it's also not too late to make a donation to get the special Zoom link for this. Every dollar helps. And if you can't purchase a ticket or sponsorship today, a contribution of any amount is welcome. After you make a donation, you'll receive an email with a Zoom link for 5 p.m. There's a donate link right now that Christine dropped into the chat box. And I know that we're at just over 72,000, which Bill had just mentioned, and approaching the 100,000 mark. Well, as Christina said, this session really focuses on income security and who's left out of the social insurance system now and what can be done to improve it. I know that was a topic of conversation this morning, and we have two amazing speakers to really help us dive into that more deeply. So we're glad to welcome these two experts. First, Rebecca Dixon, who I've had the pleasure of working with really since I first started working on social insurance, unemployment insurance, before, during, and just following the last recession that was precipitated by the 2008 financial crisis. Rebecca is now executive director of the National Employment Law Project, or NELP, which works to build and contribute to a strong workers' rights movement that dismantles structural racism, eliminates economic inequality, and builds worker power. And Rebecca has been doing that work for as long as I can remember. And I'm also delighted that we're joined by Veena Dubal, who's an associate professor of law at the University of California, Hastings College of Law. She's an expert on the gig economy, and her research focuses on the intersection of law, technology, and precarious work. And I've spent a little bit of time looking through some of her writings, and I can't imagine someone who has thought about these issues of who's sort of excluded by our social protection systems, including our social insurance systems, from so many different angles. So I'm really delighted that she's joining us as well. So let me turn it over to Christina, who's going to go through a few overview slides first.
Great. Thank you, Indy. So today we're going to delve into two aspects of income security: the classification of workers and benefits for people without work. Let's take a minute to set some context. Let's look at the first slide. So social insurance provides important income protections. Programs like Social Security, unemployment insurance, workers' compensation insure against the risk of lost income due to things like disability, losing a job, death of a worker, workplace injury. One of the common threads of these programs is that employers contribute to the funding of each of them for their employees. And those employees will receive benefits if they lose income due to any of these hardships. So we like to talk about these programs as being universal because they're not targeted by income. They're available to everyone. So next slide, please. But just because they're universal in that respect doesn't mean that everyone receives them. So on the next slide, we'll see that many people are left out of insurance and social insurance programs. So the Social Security Act excluded domestic and agricultural workers originally, which cut against African American workers in particular. People in non-standard work arrangements, like gig workers, are left out of many of these programs, as are undocumented workers. So these folks are left out of these systems, vulnerable because of it, and the effects of that, of being left out, are compounded by other injustices. Now on the next slide, you'll see a list of just some of those. So the GI Bill, African American soldiers returning from World War II were pretty much unable to access many of the benefits in the GI Bill. Redlining meant that people in neighborhoods where the majority were people of color weren't able to obtain mortgages. The Fair Labor Standards Act excluded big groups of workers like service workers, agricultural workers, retail workers. The subprime lending crisis, or the subprime lending, led to the financial crisis. And because African Americans and Latino people in particular were targeted for subprime lending, their wealth as a result of that crisis declined precipitously and hasn't really recovered all the way. And finally, mass incarceration has huge impacts on the prospects, the employment prospects for people even once they are released from prison. Now, the result of all this, there's a legacy. And on the next slide, you will see a graph that really kind of takes me aback every time I see it. And that is the huge differences in net wealth by race. So on the next slide, you'll see that white families, median white families, so your typical family has 10 times the wealth of your typical Black family. And Latino families are almost as low in terms of their net wealth. So this is the context that we're talking about when we are looking at how we need to change policy to give people more protections and more support. And one way of achieving some forms of wealth is through employment and income generation. And so that's what we're going to talk about today. Let's start with the question of worker classification and misclassification. Dina, I'll turn to you first. What is worker classification and why does it matter?
It's a really key question in today's economy. And to answer it, I want to take us back to the New Deal when these social insurance laws were first passed. Critically, when the Social Security Act was passed, when the National Labor Relations Act was passed, when the Fair Labor Standards Act was passed, when these laws that give us the safety net protections that we have today for people in the United States were passed, there was no distinction in the actual laws between people who are now called independent contractors and people who are employees. But because of the increased costs, you mentioned in your last slide, Christina, that employers have to contribute to all of these programs. And so because these programs increase the cost of having workers for employers, one of the first things that employers did was try and find a way to carve workers out of this kind of coverage. And they failed for over a decade until 1948. When we got a particularly conservative Congress, and they started passing laws that carved people who we now called independent contractors out of these acts. In fact, the law that ultimately carved independent contractors out of the Social Security Act was initially vetoed by President Truman, and what he said was this law would I'll just read you the actual veto. It says, despite representations to the contrary, this resolution would exclude from the coverage of the old age and survivors insurance and unemployment insurance systems a substantial portion of persons working as commission salesmen, life insurance salesmen, piece workers, truck drivers, taxi cab drivers, miners, tailors, and others. The Supreme Court has held that these employees have been justly and legally entitled to Social Security protection since the beginning of the program in 1935, and I cannot approve legislation which would deprive many hundreds of thousands of employees, as well as their families, of Social Security benefits when the need for expanding our social insurance system is so great. So this was in 1948, and Congress overrid President Truman's veto, and this happened in a number of different contexts. And so we had this new category for social insurance purposes of independent contractor that hadn't existed before. And so independent contractors in the United States don't have access to unemployment. They don't have access to workers' compensation. They don't have access to being protected from discrimination at work. They don't have access to the minimum wage. They don't have access to any of these things that traditional employees have access to. The idea of who an independent contractor is continues to be contested because it is a very sort of thorny legal issue. You and I might think that we can see an employee and recognize an employee for who that person is, an employee, but actually courts have come down very differently in different non-standard contexts and trying to determine who is an employee and who is an independent contractor. Critically, there's been a growth since the 1970s in what we would refer to as misclassification. So workers who are really economically reliant on their employers, who are low-wage workers, who are in no way independent businessmen, but who employers, because they want to sort of slough off the risk and liability of actually employing a workforce, who employers consider to be independent contractors. And the misclassified people occupy the janitorial industry, the construction industry, the app-based gig economy, taxi industry, truck driving industry, and these are all services. These are all types of service work that are also, not coincidentally occupied by people of color, immigrants, and undocumented people. So people that are particularly vulnerable for other reasons also tend to be the people who are misclassified, who don't have the benefits of social insurance and other employment protections. And as you highlighted at the beginning of this panel, this has had a particularly striking and stark impact during the context of this pandemic. So people who are already living in a state of crises because they have been carved out of these protections are in an additional sort of heightened sense a state of crisis in this particular moment, without access to paid sick leave, without access to workers' comp, etc.
That's really helpful, Vina. And there was some history there I didn't know myself, so I appreciate you sharing that with us. I'm going to just turn to Rebecca and ask her if she wants to add anything about this issue of misclassification, especially thinking about how it contributes to structural racism and occupational segregation. Rebecca, how do you see these issues intertwined?
Sure, Indy. So in the labor market in this country, it has always been segregated by race and gender, and Christina touched on this, and so did Vina, with double penalties for women of color. And so that means opportunity is also segregated in this country. So we know that Black workers and Latinx workers are in the most dangerous jobs, the dirtiest jobs, the jobs that pay the least. And that is intentional. That is not an accident, and that is not the natural way of things. It is an intentional way our labor market is structured, and that structural racism is baked in. We know that historically labor law has been written to say that it's race blind and universal, but if you have the labor market segregated in this way, it's very easy to carve out certain workers without ever mentioning race in your reasoning or in your in anything that you're doing related to the policy. For gig workers in particular, they are often misclassified as independent contractors. As Vina mentioned, they don't have workplace protections or benefits. And this lack of protections and benefits disproportionately hurts people of color. Black and Latinx workers are overrepresented in gig jobs and work for apps like Uber, Handy, Postmates, and Amazon Flex. So, for instance, Black workers are 12.1% of the workforce, but 23% of in-person app workers. And Latinx workers are 16.6% of the labor force, but 18.5% of in-person app workers. And when you look at the two of them together, they're about 29% of the labor force, but they make up 42% of app workers for Uber, Handy, Postmates, Amazon Flex. And so not only does this mean that they don't get unemployment insurance usually, and they're not covered by workers' compensation if they get sick on the job. So if lots of these folks are deemed essential in certain states, and so they are having to work, it means that they also don't have access to things like paid sick leave. And so they have to make the choice of whether to work sick or to stay home. And so they're in this really precarious position of being in a position where they're exposed to the public, but also unprotected.
Thank you for that, Rebecca. So you've both referred to misclassification, so of workers being classified as independent contractors when they are actually employees and should be getting all the benefits that entails. So, Vina, what can be done to ensure that workers are properly classified?
It's a really great question, and I think one of the most important questions in our economy right now. So one of the things that I've showed in my empirical research is that the traditional test to sort of determine who is an employee and who is an independent contractor that courts have applied to make this determination in contested situations is such a subjective test that, depending on someone's ideology or depending on a judge's sort of personal experience with work, that they come down differently in the same exact scenario. So, a more conservative judge might find using the same test and the same fact pattern that someone is an independent contractor versus a more liberal-minded judge might find the opposite. And this is really difficult, makes it really difficult for workers themselves to predict how they're going to how they should think of themselves or think about the protections that they get. And it also makes it very, very difficult for employers who sort of might think that they're following the law and find out that they're not. And so over the years, there has been a lot of debate over what is the best test to determine employee status. And employment and labor law scholars have been arguing since at least the 90s, although this test you can find it in workers' compensation statutes going all the way back to the 40s, have determined that the ABC test is the most clear-cut test to determine who is an employee and who is an independent contractor. And aspects of the ABC test already exist in the control test, but it sort of streamlines it. And the basic inquiry, without getting too much into the details of the test, the basic inquiry is with the ABC test is the worker who is doing the work, doing the same thing or engaged in the same kind of business as the putative employer. And if the answer is yes, then that person is likely included in the umbrella of protections that we have for social insurance purposes. So in the case of Uber, if Uber is a transportation company, then Uber drivers are engaged in transportation and therefore they are employees of that company. Critically, that doesn't mean that drivers have to, anything has to change for the drivers. It doesn't mean that they have to have less flexible schedules. It doesn't mean that they that they have to wear uniforms. All of those things are determinations that an employer might make. But what it does mean is that an employer cannot not provide workers' compensation if that person gets into an accident. That employer cannot not pay into unemployment insurance quarterly. It means that the employer has to at least provide the minimum wage. Above is absolutely fine, but that at least there has to be a wage floor. And most critically, although we're not talking about that so much in this panel, but it means that the workers can collectively organize without risking antitrust allegations. And so the ABC test, was incorporated into California law by a California Supreme Court decision in 2018 and codified into law this past year. And we have seen the second thing that's really important in order to stop misclassification, which is we're now seeing the state enforce the law. So it's one thing to have really good laws on the books, really strong pro-employee laws on the books that make the law very clear about who should be covered. It's another thing to have those laws enforced. And so we're seeing an increased number of resources poured into enforcing the law in California and actually in places in other states all over the country, in large part because the number of misclassified workers are growing. More and more money is being poured into business models that are based on misclassification. And in an effort to push back against that normalization, to push back against the creation of whole categories of workers who are laboring without any social insurance, we see lawmakers and policymakers and other government officials now sort of stepping up and willing to ensure that the most precarious workers in our economy are covered.
Great, thank you, Vina. Rebecca, is there anything you want to add to that about what we can do about misclassification?
Unmute. Sure, Christina. I would say, to build on what Vina said, there are some really practical things that states can do. So states can take administrative action to extend protections to workers who are misclassified. So they could adopt an expansive ABC definition where they explicitly say there's no exclusion for gig workers. They can also just interpret this even if they don't have it in their law. They can also create explicitly reincorporate some of the sectors that have been left out. So some states have actually passed laws that exclude gig workers from the ABC test. So states can actually reverse those. And there's also other sectors of workers that you all have mentioned, so such as agricultural workers, some domestic workers, newspaper delivery people, outside salespeople, salon workers, and truck drivers who are explicitly carved out. So states can also take a look at those in terms of explicitly including those folks in their laws, and including them for social insurance and unemployment insurance.
Thanks, Rebecca and Vina. So, it's quite clear if you're not properly classified and have, for a better word, traditional employer-employee relationship, that you have virtually no access to any social protection system. But when you think about, especially today with the large scale job losses, even for people who were in more sanctioned and recognized employee-employer relationships, the main way that we help people with the income loss from the job loss is our unemployment insurance system, of course. And what I want to do is hear a little bit from you, Rebecca, about how the unemployment insurance system, as Christina described earlier, is a social insurance system which in some ways could be perceived as universal, but of course, in fact, it leaves a lot of people out. And you and your team at NELP have been the leaders in sort of lifting up this fact. I know that when I've told reporters that 27% of unemployed workers in last year, 2019, accessed the UI system, they assume I had the number backwards and I meant 73%. Every time. They're just completely shocked. So what's going on with UI access, recipiency now over time? What are the trends? What's been sort of driving the changes? Rebecca.
Sure, Andy. And I want to just give a little context to how valuable UI is and can be. So in the last recession, state and federal UI payments totaled over $634 billion. And UI kept 11 million workers above the poverty line. So it's a really effective program when it's actually working and when folks can receive it. We know that there's this disturbing trend where workers are applying for and receiving UI at lower rates than they have in the past. And we've seen states, particularly since the recession, actually cut the number of weeks of benefits available, change their rules to make UI harder to receive, in some cases reduce the weekly benefit amount of UI that's available to workers. And so all of that has been driving rates down, and states are sort of taking the position that this program, they have to structure this program so people won't cheat the system, instead of structuring this program so that it's actually there when workers need it, when they lose their job through no fault of their own. And we're seeing in this pandemic where millions and millions of people who have never had to apply for UI or reach for UI are actually having a hard time getting benefits because the IT systems haven't been updated, because the rules are archaic, because if you're a part-time worker in some states, you don't qualify. There have been federal enhancements that have been put in place through the CARES Act on UI, but in some cases that means you have to go in and apply for the regular program and be denied, and then apply for a separate program. So we're just as a society haven't taken this program seriously in terms of the way we finance it, in terms of the way the states have different rules. So depending on which state you live in, you may have a very secure UI program. You may receive something like $700 a week as a benefit over 26 weeks, or you may be in a state where the benefit is $235 a week and you only end up with 10 weeks of benefits. So it really does just vary, and we really should actually stabilize and put in a floor on this program, because as we talked about, certain workers end up being the ones who are left out or who are in states with very porous programs. So 55% of Black workers live in the South, and the programs in the South tend to be the ones with the lowest pay and also the lowest recipiency.
That brings up a question that came up from the audience earlier today about the state variation, and questions about whether that's contributing to inequities and whether we need to rethink the role of states versus the federal government, and even moving, should we federalize these programs? What do you think about that, Rebecca?
I would love it if there were some federal baselines in this program around the amount of benefits, the percentage of your previous wage that it replaces, that there was some baseline you could depend on in number of weeks, that was the same for every state. I would love it if there was federal investment in information technology infrastructure for UI programs, so that when we have a situation like we do now, where there's a huge crush of applicants, the system can actually quickly expand and service them. And definitely we need to have financing reform. And I think that there are different schools of thought in terms of whether that should be federalized or whether states should choose to do this on their own. But I think there are important opportunities for the federal government to lead the way, particularly around financing, where they could raise the taxable wage base. So the basis of which the UI tax is based on hasn't been raised since the 80s. So imagine if we had not raised the Social Security taxable wage base since the 80s. So in some ways, we have this program set up to starve it financially. And so what we're seeing is not unusual. And then there's ways in which we need to just modernize the program. We know this program was designed for able-bodied white men in the 1930s who had full-time jobs, who had temporary layoffs, and our labor market and our workforce is completely different now. And so there are simple things we could do, like fixing the part-time eligibility situation, expanding the good cause reasons for leaving a job, really making sure that we are thinking about this program and modernizing it so it can actually do what it's designed to do, instead of sort of having it still running on this old system where it's still excluding lots of folks, particularly when they need it most right now.
Thank you. Dina, do you want to add anything about the current economic crisis and what we're seeing in the unemployment insurance system?
Yeah, I want to add two things to the great points that Rebecca made. So I think that we also fundamentally need to rethink on a federal level. Of course, this is not happening with this Congress or this administration, but project in the future a rethinking around the requirement that in order to get unemployment insurance, you have to get it through if you've been terminated through no fault, so no fault of your own, because traditionally, even before the pandemic, it's this notion that the only way you can get unemployment insurance is really if you're laid off through no fault of your own, that employers have used to fight tooth and nail, giving people access to this safety net benefit. And it was when we got unemployment insurance in the 1930s, this was seen as the more conservative stance, and I think we know from experience now, decades of experience, that it is a problem for access, and it's something that we should fundamentally rethink. In addition to the technical difficulties and the funding difficulties, and the fact that the amount is so low, I think that what this pandemic has. The reality that it has sort of brought to light for states themselves is that without enforcing the payment of unemployment taxes against intransigent employers, like Uber, like Lyft, like Handy, like Postmates, all of these companies who have not paid into unemployment insurance for the past almost decade, that the funding for these programs is just not there. And so in California, we know that they owe something slightly less than $1 billion just to Uber and Lyft into these unemployment insurance programs, and we as a state don't have that money to give to people, and it's been hard. We've been the first state to have to borrow from the federal government to pay into our state unemployment insurance program, and that means that law-abiding employers are going to have their unemployment insurance taxes go up in the coming years to make up for that money. And so I think that that's something that we really have to focus on, that states really need to be focusing on moving forward, is actually, again, enforcing unemployment insurance taxes against intransigent employers. I wonder if Christina, if I could talk a little bit about how California has treated Uber and Lyft drivers in the context of unemployment. It sort of, I think, is a very good example of all of the problems that Rebecca laid out and that we've been talking about in this panel. So Uber and Lyft drivers are very clearly employees for purposes of unemployment insurance in California. This was true before we passed AB5 and got the ABC test, and this has been true since January 1st, since we've gotten the ABC test. We know that Uber and Lyft drivers have gotten unemployment insurance in California prior to the pandemic without any problem. However, when the pandemic began, there was a question of, how is the state going to treat these workers? We haven't seen enforcement of AB5 yet, and there was a lot of talk on the federal level about gig workers and getting a different kind of what ended up being called pandemic unemployment assistance to people who were gig workers or independent contractors. And so California Uber and Lyft drivers are really getting mixed messages. On the one hand, the federal government passed the CARES Act, which gave extended unemployment insurance to independent contractors, and they kept saying gig workers. And then in California, we have lawmakers saying, no, these workers deserve unemployment insurance from the state. And I think from the perspective of someone who isn't watching this closely, it just seemed like, well, who cares, right? They're going to get unemployment insurance somehow. So who cares whether they're getting it from federal money or whether they're getting it from state money? Well, it actually matters a lot and continues to matter a lot. So gig workers, if they get state unemployment insurance, then they get hundreds more dollars a week more than if they get pandemic unemployment assistance, and that is because state unemployment insurance is based on gross income as opposed to net income, which is what the pandemic unemployment assistance is based on. And so they were just getting completely mixed messages based on who they talked to, whether even when they called the EDD, the state unemployment insurance agencies, they were getting told by trained people at the EDD that no, you have to go through the pandemic unemployment assistance. And then they said, well, but I'm an employee. Why do I have to do this? And so over the past, I don't know how many weeks it's been, 16, 17 weeks, there are still Uber and Lyft drivers who have not received their unemployment insurance, who are still stuck in the system because people within the EDD don't know how to treat them. Because there's been a refusal to streamline their benefits to ensure, because there's no funding in the system, because the Uber and Lyft haven't been paying into the system, to make sure that they get the state unemployment insurance. And so you have some Uber drivers who pushed really hard, talked to the right people, and got state unemployment insurance and are getting exactly what they are owed. You have some who were pushed into the pandemic unemployment assistance program who are getting hundreds less than what they are owed a week. And you have some who are still stuck in the middle who don't have anything. And so you have, again, these low income people of color, immigrant workers in the service economy who are really being mistreated, not just by their employers, but by a system that is unclear, very technically difficult, underfunded, and a sort of a bureaucratic mess. And it's been a just emblematic of the broader, I think, problems that we have with the administration of unemployment insurance more broadly.
Thank you, Vina. And Rebecca, what do you think about this general approach Congress took in this pandemic to try to reach independent contractors and other workers left out of UI? Do you think that it makes some sense? We should build upon it, or should we take a different approach altogether?
As Vina mentioned, it is a program that covers them at a lower level of benefits. I think that certainly it's definitely better than nothing, and definitely better than being left out, which is how most of them have been treated unless there's a disaster. This program is based on disaster unemployment insurance. So when there's a natural disaster, say Houston has flooded or there's wildfires, when there's a federal disaster declared, these workers, so people who are self-employed, who are independent contractors, and gig workers who are misclassified, would be brought into the UI program under the disaster unemployment program, which does have lower benefit amounts. So we would want them to have the adequate protection that everyone else has. And as Vina has talked about, we actually need states to collect unemployment insurance taxes from these employers so that they can actually make these programs work. I think that one of the pieces that we've seen here that mirrors what we saw during the New Deal. So in the New Deal, it's like we can't include agricultural workers because it's too hard to keep up with their wages, and it's too hard. And I've heard that about this and including these workers in UI, and it's not too hard. this is the United States of America. We can figure out how to do anything. And I think we have to decide whether we want to be inclusive or not. And we decided in the last really deep financial downturn that we didn't want to be inclusive. And I hope that we as a country make a different choice this time around.
Great. Thank you, Rebecca. So now we're going to turn to questions from the audience, and we have two already. One
Can I add one thing? I'm sorry.
Oh, sorry.
Christina, can I add one thing? And I just think it's just an important piece of food for thought for us to go into Q&A is that, I really think that we need to not just to think about extending all of these benefits to all workers, but also disentangling our employment system from our social insurance system. Because so much of what we're talking about is, the fact that people are being misclassified, the fact that there are these non-standard work arrangements that result in misclassification. So much of this is really based in the reality that employers are incentivized to misclassify their workers because it is so expensive to have, or it is more expensive to have to employ employees. And so, if there is sort of a disentangling of employment from social insurance, I think that we might have some of these issues go away.
Thank you. So one of the questions talks about undocumented workers. So some undocumented workers pay into Social Security, but they're not able to draw benefits. And so how do you think about, when you think about undocumented workers and social insurance programs based on contributions to the system versus social assistance programs like Medicaid? How do we think about that? So, Vina or Rebecca, who wants to jump in?
Why don't I set it up and just talk about what UI eligibility there is for immigrant workers, and then Vina, you can tag team. So this is a question we get a lot, and basically there's two time periods for immigrant workers that is looked at. It is the time that they earned the wages. So the look back period, did you earn enough money to qualify for UI? And then the period of time where you're actually collecting the UI. And in both of those cases, you have to have legal status to work in order to qualify for UI. So just want to sort of put that out there so that the audience knows that that's how it works.
I mean, this is a huge problem, right? That we're in the middle of a pandemic, and we have many undocumented workers upon whom our economy relies, many undocumented service workers, many undocumented food workers, and these people who are more likely to also be sick because they've been exposed to the public in a more robust way than those of us who sit in desks and in offices. They are completely cut off from all of the social insurance. This is not good for their health or their family. This is not good for public health. This is it's really a disgrace that in the wealthiest country in the world, we have millions of workers upon whom we rely to get food, to function, that these people are carved out of the social insurance system. It is just a disgrace. And in California, there is a program that Governor Newsom has instituted in which workers get a small amount of money, and undocumented workers can apply to get a small amount of money. It is not comparable to unemployment insurance in the amount. It is not comparable in terms of the longevity of what they get. And the stories I've heard from undocumented workers are nothing short of heartbreaking and immoral. It's immoral that this is the situation that these folks are in.
Thanks to you both for your comments. Now, another question has come in talking about the emergency UI benefits, this extra $600, and there are concerns that when UI benefits exceed a worker's regular wages, that it provides a disincentive for them to go back to work. So what do you think the issue is here? What do you think about those concerns?
I would say that, one of the most important things about work that like all of us get other things from work besides money. And so if we want to sort of operate under the assumption that folks need to be incentivized to go back to work or that folks are somehow lazy, but that's not how I look at my fellow Americans and workers. I look at them as folks who are doing the absolute best that they can. And so even if a worker was to get more money in UI for a few weeks versus what they earn, the UI program has already built in things that are basically set up to catch the worst case scenario. So you do have to be available for work as part of UI. You have to be actively looking for work, and you have to take a suitable job offer. So it's not like you get the UI and there are no rules around it. So I think, we should just think about putting it into context. If you're out of work, most of us, as Vina said, get our health insurance from our job. If we're out of work and we're having to pay for COBRA, we're having to pay the full price of our health insurance. So that $600 could be eaten up really quickly.
And one of the most conservative Congresses that we have ever had has come up with this number, this $600 number. And then they realize that people were making less than that amount per week all over the country. And what this says is not that the number is too high, but that wages are too low. We have not had a federal minimum wage increase since 2009. The federal minimum wage is set at $7.25 and a fraction of that for tipped workers. We have long known and been advocating for a raise in the minimum wage. I think that rather than looking at this scenario and saying, oh, we made a mistake, we gave them too much money, I think that what this tells us really is that people are paid too little for the hard work that they put in every day. And I really hope that is the policy lesson that Congress is able to draw forth from this disaster.
Well, thank you so much, Dina and Rebecca and Christina. So we actually need to start wrapping up. But before we go, I just wanted to quickly remind folks about donating. I think we're going to get another link dropped into the chat box. And really thank you for all those who have responded already. Just thinking about some of the things your donation makes possible in this conversation. The Academy is just, for example, right now working on a unemployment insurance efforts, including some publication. I think Colleen already dropped the link into the chat box, but also potentially a new task force on strengthening the federal role in unemployment insurance, which, as you've heard, might be hugely consequential, including in particular for racial justice. But also the Academy has been making sure journalists have access to a lot of the top experts on UI issues and others as well during this crisis, which has been really crucial. So the goal is to raise 100,000 by June 30th, and we're much closer. We've already topped 75,000. So you can see that here in the thermometer. And thanks to Alison Norris, a new Academy member, Bill Rogers, the chair, Palolo Ijikazi, Nancy Altman, both longstanding members, and Tyler Bond and Harry Conaway as well, and Carol Estes for your contributions. And we'll have more people to thank later this afternoon as the Academy staff count up the additional contributions coming in. But again, maybe a visual sort of applause for Vina and Rebecca and Christina as well for their terrific conversation. The writings are well worth reading. And I think there's also a link that we can share with everyone to the Academy's unemployment insurance discussions. The Academy's unemployment insurance publications as well. So with that, maybe I'll turn it over to Elaine for a transition.